Ready.
About the bar. Warm welcome and a happy new year.
Thank you. Same to all of you.
His Lordship. Lordship, I'd like to mention item number 11, Lordship, on behalf of Nelson. Can you grant me 2 weeks time to file my condom
You are for,
for state respondent, Lordship?
you are for,
I'll for the petition.
you don't have any objection.
Yes, Lordship.
Heard Mr. Foseco Forte.
For private respondent, 5.
What's your name?
Yes, come.
Heard Miss S. Chan, learned counsel for the state respondent, who prays for an adjournment. The Mr. T. Pongner, learned counsel for the petitioner, as well as Mr. Foseco Forte, learned counsel for respondent number
5, Lordship.
5, does not object to the said prayer, hence the prayer is allowed.
Lordship, in the interim, may we continue.
Let this matter be listed after 3 weeks, 2 weeks, 3 weeks. The interim order shall continue till next day.
Much.
Lordship, I have similar prayer for item number 12 on behalf of Tiba, Lordship. Item number 12.
May I please, my lord, I'd like to make one submission, Lordship. In the interest of justice, Lordship, this matter can be expeditiously disposed of, Lordship, because this is a World Church employee regularization case, Lordship.
No, what is your,
Lordship, the petitioner is squarely covered by the office memorandum, Lordship.
no, today she is praying for an adjournment.
Yes, Lordship, but Lordship, direction to that effect could be passed to expeditiously pursue this dispose of this petition, Lordship.
We can only deal with adjournment prayer today. We will give a fixed date for admission hearing.
Yes, Lordship.
Heard Miss S. Chang, learned counsel for the state respondent, who prays for an adjournment on behalf of
Tiba home.
E.T. Bafom, learned government, senior government counsel. Mr. T. Toshi O. Long Kumer, learned counsel for the petitioner, though concedes to the prayer, prays for expeditious hearing of this matter. Considering the submissions of learned counsel for the parties, the prayer is allowed. Let this man, you want a fixed date?
Yes, Lordship. First of March, Lordship.
Let this matter be listed again on 21st of March.
Lordship, there are 4 analogous matter. If those 4 could be also club up together with this.
With this, today,
Yes, Lordship.
today it is not listed.
It is not listed today. It was listed last week, Lordship.
Who are the petitioners?
Petitioner,
You are representing the
I'm
petition.
representing both of all the petitions. WBC number 86 to 89. 2023.
Learned counsel for the petitioner also submits that there are 4 other analogous matters which may be listed along with this writ petition, namely WPC 286
286 to 289.
slash 223 to 289 slash 23. The prayer is allowed. The said writ petition be listed along with the instant writ petition on 21st of March for admission hearing.
Much.
Please, Lordship. Lordship, I'd like to mention item number 5. I may be allowed 3 weeks time to file affidavit in reply, Lordship. I am for the respondent number 5.
Heard Mr.
W. Marfu, Lordship.
W.
Marfu.
Marhu, learned counsel for the respondent number 5,
Yes, Lordship.
who prays for 3 weeks' time for filing affidavit in opposition. Learned
Counsel for the petitioner, cancel.
Ms. N. Solo, learned counsel for the petitioner, does not have any objection to the said prayer. Hence, the prayer is allowed. Let
Much
this matter be listed after
True.
3 weeks.
Much obliged.
May I please, my lord? Lordship, I beg to mention item number 19. Lordship, I am appearing for respondent number 1 here. If sometime it can be granted to me to receive the necessary instruction, your lordship. As for the other respondent, your lordship, on the last occasion, notice was incomplete, your lordship. For respondent number 2 to 7, my lord.
What is the status now? Today? Whether two
No,
to
your lordship, I have no instruction to appear on their behalf, except for respondent number 1, my lord.
Heard Mr. N. Angami, learned senior government counsel, who prays for some more time for seeking necessary instructions from the state respondent number 1.
One.
Mr. S. Walling, learned counsel for the petitioner, does not have any objection to the same. Accordingly, let this matter be listed after 3 weeks.
Lordship, for item number 18, I have a similar prayer on behalf of my colleague S. Mary. She is appearing for all the respondents here, my lord.
Learned Mr. N. Angami, learned senior government counsel, submitting on behalf of Ms. S. Mere,
Lordship.
prays for some more time for seeking instructions,
yes.
necessary instructions from the state respondent in this matter. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed after 3 weeks.
Lordship. Lordship, I also beg to mention item number 22 on behalf of my colleague Inahuli. Lordship, I'm told that she is yet to receive instruction in this matter. So if 2 weeks' time can kindly be granted, my lord?
Yes, Mr. Heard Mr. N. Angami, learned counsel for the learned senior government counsel, submitting on behalf of Ms.
Inahuli, your lordship,
Inawali,
who is yet to receive necessary instruction as directed by this honorable
who
court, your lordship.
seeking for some more time for getting necessary instructions from the state respondent. Mr. Moha Jamir does not opposes the prayer. Let this matter be listed after 2 weeks.
I'm deeply obliged.
Your Honor, if I may speak,
Yes.
item number 15. Case WPC 6/2022. I'm the petitioner number 2 in the case. I would like to request for an adjournment.
Lordship, that is item number 15, Lordship.
What's your name?
My name is Barbara Nunes. I'm petitioner number 2 in this case.
Don't have any objection.
No, Lordship.
The petitioner in person who seeks for an adjournment in this case, learned Mr. Foseko Forte, learned counsel for the
1.
respondent number 1, opposes the prayer, hence the prayer is allowed. How much time
Thank
you,
you, Your Honor. 2 weeks, please, Your Honor.
let this matter be listed after 2 weeks?
Thank you, Your Honor.
Lordship. 3 weeks.
3 weeks,
3 weeks.
after 3 weeks.
Obliged, my lord.
Thank you, Your Honor.
Yeah, please, the lordship.
May it please,
Yes,
may it please your lordship. I beg to mention item number 16 and 17, my lord. In this case, my lord, I was directed to issue fresh notice on correct address, my lord. I require some more time to find the address, my lord.
Ms. S. Kakoti, learned counsel for the appellant, who seeks for some more time for getting the correct address of the respondent, for taking steps for issuance of notice on the said respondents. the prayer is allowed, let this matter be listed after how much time you want?
4 weeks, my lord. A date may be fixed, my lord, if
No,
possible.
no fixed date, after 4 weeks.
My lord. Early obliged.
Lordship, I think to mention item 27. This matter can come up after 2 weeks.
There's an Indian water service.
Heard Mr. V. Zimomi, learned public prosecutor, who prays for an adjournment for 3 weeks.
2 weeks.
2 weeks, Mr. Yangarvati, learned counsel for the petitioner, does not opposes the prayer, hence the prayer is allowed. Let this matter be listed after 2 weeks.
Lordship, Indian water will be
The interim order shall continue till next day.
first lordship.
Lordship, I think to mention item 26. If this matter can come up after 2 weeks.
Instruction go on.
You are for?
I'm for the state response.
For the petitioner.
Heard Mr. V. Zimomi, learned senior government counsel, learned government advocate Nagaland, who prays for 2 weeks' time. Miss M. Solo,
No, I'm Kelly Lisu, respondent number 5.
who is for the petitioner? Manek? Yes, yes. Mr. M. Konyak, learned counsel for the petitioner, does not opposes the prayer. The prayer is allowed. You are for, show her name for respondent number
5, Accountant General.
5. The prayer is allowed. Let this matter be listed after 2 weeks.
No objection.
Mr. V. Zimomi, learned government advocate Nagaland, he seeks for some time prays for some time for seeking necessary instructions from the state respondent. Learned counsel for the petitioner does not opposes the prayer, hence the prayer is allowed. Let this matter be listed after 2 weeks, 3 weeks.
Lordship, I beg to mention item 7. And for the petitioner, I've received an affidavit in opposition filed by the private respondent. So I may be given 2 weeks time to file my reply.
Heard Miss
It's
S. Sukru, learned counsel for the petitioner, who submits that she has received the affidavit in opposition filed by the state respondent
as
and
well as the private respondent.
as well as by the private respondent, and prays for some time for filing the affidavit in reply. The learned counsel for the respondent, state respondent as well as private respondent does not opposes the prayer, hence the prayer is allowed. Let this matter be listed after 3 weeks.
May it please your lordship. Your lordship, I beg to mention here in item number 29. Your lordship, I agree this matter be listed after a week.
Heard Miss V. A. Thierry, learned counsel for the petitioner, who is for the, you don't have objection, who prays for an adjournment for a week. Learned government counsel does not opposes the prayer, hence the prayer is allowed. Let this matter be listed after a week.
Deeply obliged.
May I please your lordship, I beg to mention item number 3. Kindly grant me 2 weeks time to file affidavit in reply to the additional affidavit filed by respondent number 1 to 5.
What's your name?
Kelly Lisu.
Oh, heard Ms. K. Lily Su, learned counsel for the petitioner, who prays for some more time for filing affidavit in reply against the additional affidavit filed by respondent number
124.
1 to
Oh,
4,
125.
1 to 5. The prayer is allowed. Let this matter be listed after
2 weeks.
2 weeks.
Yes. Inshallah.
Yes, Your Lordship. Your Lordship, I'd like to mention item number 6. Here I have received affidavit in opposition filed by the state this morning. Your Lordship, may kindly allow me some time to go through the affidavit.
Okay. You will be filing reply.
If necessary. Your
Okay.
Lordship.
Heard Ms.
Is challenged.
H. Ziliang, learned counsel for the petitioner. Also heard Mr. Moaim Jain, learned senior government counsel. Learned counsel for the petitioner submits that she has received the affidavit in opposition from the state respondent only today,
1 to 9.
1 to 9, and she needs some time to go through it so as to decide whether to file affidavit in reply or not. The prayer is allowed. Let this matter be listed after 2 weeks.
Next, Your Lordship, I'd like to mention item number 9. Let the matter may be fixed on 11/3/2024. In the meantime, I'll file my written reply for all the respondents.
What's your name?
Nang Sangayan.
Don't, no objection. Heard Mr. Nansan Iyer, learned counsel for the petitioner, who prays for 3 weeks' time for,
Lordship.
no, who prays for fixing this matter on
11/3/2024.
11/3/2024. The learned counsel for the state respondent as well as private respondents does not have any objection to the said prayer. Hence, the prayer is allowed. Let this matter be
Lordship,
listed.
in the meantime, I'll file my written reply by this week.
Let the matter be listed again on 11th of March. 11th March,
Yes.
11th of March.
In the real matter,
The petitioner may file in the meanwhile file the affidavit in reply against the affidavit in opposition filed by the respondents. Stop. The interim order shall continue till next date.
May I please, Lordship? I'd like to mention item number 24. On behalf of respondent number 2 and 3. Lordship, I pray that the matter may come after a week. No objection.
Heard Mr. M. Konyak, learned counsel for the respondent number
2 and 3.
2 and 3, who prays for an adjournment for the day. The Mr. Foseko Fote, learned counsel for the petitioner, does not opposes. Learned counsel for the appellant does not opposes the prayer.
Lordship, 1 week time.
The prayer is allowed. Let this matter be listed after a week.
May I please, Lordship? Lordship, I beg to mention 4, Lordship. Item 4. Lordship, I filed my reply to the free file by respondent 2 to 4. Lordship, I've been informed that the respondent 1 has not received any instructions. The Ministry of Finance. Lordship, better come after 2 weeks, Lordship.
You have informed.
Yes, I'm informed. I've informed Mr. Gauhati.
Heard Mr. Foseko Forte, who submits that he has filed his reply to the affidavit in opposition filed by respondent number 2 to 4. It is also submitted that he has been informed by learned counsel for respondent number 1 that they have not received any instructions from this central government. Considering the submissions made by learned counsel for the petitioner, this case is adjourned for 3 weeks, 2 weeks. Let this case be listed accordingly after 2
In the
weeks.
meantime, let the interim continue, Lordship.
The interim order shall continue till next day.
Highly obliged, Lordship.
Recommendation agreement number 8.
8. Yes,
Lordship, I was informed from the council for respondent number 2 that she will be filing the affidavit tomorrow. So let the matter be listed as a week.
heard miss. What's your name?
I am mentioning. I'm going on behalf of Mr. Tom.
Mr. Miss?
I'm going on behalf of.
Repeat your name.
I am mentioning.
I.L. Imchin. Submitting on behalf of Mr. Tongpok Pongne, learned counsel for the petitioner. You are for? State respondent. Submits that the respondent number 2 will be filing. The respondent number 5, she has been informed that respondent number 5 would be filing their affidavit in opposition tomorrow only. And on that ground, she prays that this case may be listed after a week. The learned counsel for the state respondent does not opposes the prayer. Hence, the prayer is allowed. Let this matter be listed. Let this matter be listed after a week. The interim order shall continue till next day.
I can do the trigger. It's not come after 1 week. On behalf of INE
Heard Miss S. Chang, learned government counsel, appearing for respondent number 1 to 3. Praise for how much time? 1 week time. The learned counsel for the petitioner does not have any objection. Hence, the prayer is allowed. Let this matter be listed after a week.
Much too much.
I'd like to mention hearing item number 25. Which by private measure may be just the following.
You are for?
Petitioner.
Heard Mr. M. Konyak, learned counsel for the petitioner, who prays for, you have informed the
Yes.
respondent's counsel, who prays for an adjournment for a week. He also submits that he has informed learned counsel for the state respondents. Hence, learned central government standing council. And accordingly, the prayer is allowed. Let this matter be listed after 1 week.
For motion, item number 1.
So this is an application of the section 482 CRPC for crushing criminal complaint 2 of 2019 pending before the Chief Judicial Magistrate Moon. Actually, there was a dispute. This matter is arising out of a land dispute between 2 villages. Respondent's village is from Lianha and the petitioner's village, the present petitioner is the Ang of the village. Ang is the chief of the village, so he is representing the petitioner's village. There is a checkered history of litigation in the past also. And in view of the land dispute, the district administration was also involved. And then the district administration has decided to go for the oath taking with the consent of both the villages. When there is a dispute, customary oath taking, that is oath. They will swear in the name of God by taking oath, by biting the soil of the disputed land with some promises and with some resolutions. So the resolution was, after biting the soil, in which village the deed occurs first shall be the loser.
What
So they have
what occurs
left-
first?
They have
Death.
left to divinity
Okay,
to be decided by the divine intervention. So if the deed arose
death of whom? Anybody?
in any of the village, any person
Okay,
in whose village the deed occurs first will be the loser. So it so happened that as luck would have it, the respondents' village, the deed occurred first. So they were declared as loser.
in the land dispute.
Yes.
Okay,
But then, although they have taken a solemn oath, they have not accepted the verdict of the divine intervention.
okay.
Therefore, there has been a lot of litigation. After a series of litigation, it all ended with a trial before the district judge, Moon. And the verdict was given on 22nd February 2018, 2008, by the ADC Judicial Moon.
This was a civil dispute.
Yes,
See,
and the verdict was given in favor of the present petitioner's village. Having not satisfied with that verdict, the respondent's village, they approached this honorable court. This honorable court has also dismissed their writ petition. Therefore, the matter as of now is settled by the verdict of the Additional Deputy Commissioner Judicial Moon by order dated 22/2/2008.
okay. That
So-
verdict was in your favor.
Yes. Now, it is a Chomlan area. Therefore, after the verdict was given, since the matter was pending for a long time, and during the pendency of the writ petition before the High Court, none of the parties have cultivated with that. Although it was decided in our favor, we have complied with the order. But after the case was disposed of by this honorable court, dismissing the writ petition filed by the respondent's village. Next year, we cleared the jungle for terrace cultivation
Okay,
in 2018, sorry. And after clearing the forest, normally they have constructed the thatched houses for granary for this petty cultivation. Those houses, 5 houses were destroyed by the respondent's village. They have burned down the thatched houses, temporary thatched houses, which were constructed in the petty field, the farmhouse, were burned down by the respondent village. Therefore, we have lodged a complaint to the district administration against the respondent's village. It was finally heard by the extra assistant commissioner. They are the district administrative officers who is in the lowest rank. So he has decided, and by referring to the judgment, which was passed by the additional deputy commissioner on 22/2/2008, the EAC has affirmed the judgment and resolved. Having not satisfied with the verdict of the extra assistant commissioner, again, the respondents' village, they have filed an appeal before a district judge, Moon. And that petition was also dismissed.
okay.
The respondent number 2 has filed, that was dismissed. And for destruction of our granaries, we have filed a criminal complaint against him, the respondent number 2. And he was taken to prison also. He was in the prison for some time. And before the charge sheet could be filed, the respondent number 2, the present respondent number 2, who was in the prison for some time, he filed a criminal complaint against the petitioner's village.
Complaining what?
And
What was the allegation?
contending that we have misinterpreted the orders passed by this honorable court and the order passed by the Additional Deputy Commission. They tried to create a fresh controversy out of the case, since they have lost in all the proceedings. Now, after the case was decided by the ESC, it was taken to the DC, and in all the proceedings, they have lost. So, but the charge sheet could not be filed under complaint,
On whose complaint?
on my complaint.
Because there is one your
Yes,
complaint,
there are
one
two complaints, correct,
respondent number
exactly.
two's complaint.
Correct, Lordship. On our complaint, charge sheet could not be filed. So in order to avoid that, in order to obstruct that filing of charge sheet, the respondent number 2 has filed a complaint against me. This is the present complaint, namely complaint application 2 of 2019.
Okay.
That was filed against me, alleging that we have misinterpreted the order passed by the court. And another allegation was made that there is criminal trespass. We have committed criminal trespass. The offense of criminal trespass.
Over which land?
Over the land which is already decided.
This land is situated where? That disputed land, where it is situated?
It is a place called Changhong Changli. It is a big chunk of land. Under that Changhong Changli, by home burning, one particular area which the one will say that this particular area.
No,
is not
now
included.
the complaint 2/19.
Yes,
In that complaint, the allegation against you by respondent number 2 is that you trespassed into this Changhong Changli.
yes,
That is the allegation?
yes.
Okay.
Whereas in the series of litigation, the verdict was in my favor.
In respect of that land.
In respect of that land. And it is purely a civil dispute. Therefore, the learned Chief Judicial Magistrate could not have,
CJM Mon.
yes, CGM1 could not have registered the criminal case against the petitioners. That is the sole grievance, Lordship. It is a civil dispute. And looking at the complaint which they have filed, all the statements, allegations are pertaining to misinterpretation of the court. So Lordship is well aware, if any of the parties misinterpreted any of the orders passed by the court, then the parties will have two options. One, if the order is violated, they can initiate contempt proceeding. Or if there is any confusion, there is always alternative remedy to take alternative course of litigation, either by way of appeal, either by way of clarification. On the face of the complaint, there is no commission of any criminal offense by the petitioners. Therefore, the petitioners are before the Senable Court to quash the criminal complaint 2 of 2019 filed against the present petitioners. And the issue arising out of this dispute has been decided by the Extra Assistant Commissioner.
Where is the complaint?
Complaint, Lordship will find it page 89. No, complaint will be at page 91. So, 91 and Lordship. Just, I will take your Lordship to the relevant portion, page 101, paragraph 7. Because after setting many things, this is the concluding paragraph, page 101, paragraph 7 on the top, Lordship will find. May I read, Lordship?
Yes, misinterpreting.
That it is respectfully submitted that the accused respondents and their village, that is Totok Chingyu, this is the present petitioner, should not be allowed to go scot-free for misinterpreting the judgments and orders of the honorable courts in an open act of contempt of court. So this is the sums and substance of the complaint. And Lordship will find in the entire complaint, they are making the allegation about the misinterpretation of the court order. So it is purely a civil nature. And registration of a criminal case doesn't arise, Lordship.
We shall have to go through the
Records.
records. And why this is registered as criminal revision petition? This ought to have been
Yes,
registered as
Lordship.
criminal petition.
Initially, Lordship, what happened? I have left out that part. Initially, we have filed the similar petition before the honorable court. It so happened that when Lordship Chief Justice Ajit Lamba, he came, and on 3rd of December 2019, he arrived to a conclusion that no, you can go to Sessions Court Moon, and then you can file a revision petition there. And the petition was disposed of, giving liberty to the petitioner to approach the Sessions Judge Moon.
Against which order?
Against this for quashing the criminal complaint.
2/19.
Yes. The Sessions Judge Moon, I believe it is a recent order. She has not agreed with the order passed by this honorable court, because as per the provisions of CRPC, a revision will lie only before the High Court. I'm not disputing that order. I think this is perfectly in accordance with law. That is what I feel, Lordship. So it is again back to square one. Initially, we feel a similar.
No,
application.
but this is a petition under 482 or 401.
482.
So this ought to have been registered as criminal petition instead of criminal revision petition.
Yes. Criminal.
Because if wrong,
Technically, yes.
it raises the confusion later on.
Lordship can convert it also.
Okay. Yes, Mr. Zimomi.
And
We
the
are-
court may be called at this stage.
Heard Mr. C.T. Zamir, learned senior counsel for, assisted by Mr.
M. Kong Chamir.
Eng
M. Kong Chamir.
Inkong Zamir, learned counsel for the petitioner. Also heard Mr. V. Zimomi, learned public prosecutor representing the state of Nagaland. This application under section 482 of the Code of Criminal Procedure has been filed by the petitioners praying for quashing of complaint case number 2/2019, which is pending in the Court of Chief Judicial Magistrate, Mon, Nagaland. Learned senior counsel for the petitioner has submitted that in the complaint petition, the complainant, that is the respondent number 2, has raised issues regarding misinterpretations of earlier judgments of this court as well as, earlier judgment of this court as well as other courts regarding a land dispute between two villages, namely, what are the villages?
Liangha village and Totok Chengyu village. Liangha and Totok Chengyu.
Yes, which according to learned senior counsel for the petitioner was decided in favor of the village to which the present petitioner belongs by judgment dated 22/2/2008 passed by ADC
Judicial, within bracket judicial.
within bracket judicial mode. Learned senior counsel for the petitioner has also submitted that the contentions raised by the respondent number 2 in his complaint petition in complaint case number 2/2019 are only reflects that there is a civil dispute between the parties, and under such circumstances, it is submitted that learned Chief Judicial Magistrate Mohan has committed, has erred in taking cognizance of the complaint filed by respondent number 2. Issue notice to the respondents and call for the scan copy of the case record of complaint case number
Criminal complaint.
criminal
case number
complaint 2 of 2019. Since Mr. V. Zimomi has appeared, since Mr. V. Zimomi, learned public prosecutor Nagaland, has appeared for the respondent number 1, no formal notice need to be sent to respondent number 1. However, as regards the respondent number 2 is concerned, the petitioners shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from date of this order, returnable after 4 weeks. Let this matter be listed after 4 weeks.
And Lordship, during the pendency of the writ petition, this criminal petition, the proceeding may be suspended.
This prayer will consider only after service of notice on respondent number 2. The prayer for interim relief made by the petitioner shall be considered only after service of notice on respondent number 2.
Obliged.
From the supplementary cost list for motion, item number 30.
Yes, Your Lordship.
Yes.
Yes, Your Lordship, by filing the present petition, Your Lordship, I'm praying for cancellation of bail that was granted to the accused persons, Your Lordship, by order dated 22nd December 2023. Here, Your Lordship, what has happened is that on the night of 18th November 2023, Your Lordship, the deceased was brutally assaulted by 5 persons, Your Lordship, who are also included as respondent number 2 to 6, Your Lordship. And he succumbed to his injuries on 1st December 2023, Your Lordship. And despite serious charges against the accused persons, Your Lordship, they were granted bail by the learned principal district and sessions judge, Your Lordship.
Okay. Have you approached the session judge for cancellation of bail?
No, Your Lordship, I'm the police honorable. Your Lordship, this application is filed under section 439 to Your Lordship.
Will issue notice? Yes, Mr. Angami. Heard Mr. V. A. Terry, learned counsel for the petitioner also heard Mr. KV Angami, learned public prosecutor for the state of Nagaland. This application under section 439 within bracket 2 of the Code of Criminal Procedure, 1973 has been filed by the petitioner, Mr. P. Kakiho Owomi, praying for cancellation of bail of respondent number 226, which was granted by learned Sessions Judge Dimapur in IA within bracket bail number 755/2023. Stop. Issue notice to the respondents and call for the case record of IA within bracket bail number 755/23 from the Court of Learned Session Judge Dimapur. As Mr. KV Angami, learned public prosecutor, has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. However, as regards the respondent number 2 to 6 are concerned, the petitioner shall take steps for issuance of notice on respondent number 2 to 6 by registered post with AD within
1 week, Your Lordship.
within
2 days.
2 days from the date of this order, returnable on after 15 days.
Your Lordship, I may be allowed to take steps to the officer in charge, Your Lordship, to the officer in charge of this police station upon the private respondent.
Before that, the petitioner may also take steps for issuance of notice in addition to registered post with AD to serve the notice on the respondent number 2 to 6 through the officer in charge of East Police Station, Dimapur, Naga. All are same police
Yes,
station.
Your Lordship.
Dimapur, returnable on. The notices issued to the respondents are returnable on which date? 18. Okay, on 18/3/2024, list accordingly.
Deeply blessed.
For admission, item number 10.
Hearing on behalf of East Wing.
Yes,
Lordship, I am for respondent, primary respondent 6 to 4,
6 to
14.
who is for the state? State respondents have not filed any affidavit.
Vijay Momi is present in the state.
Okay,
I was just told that he has not received a copy of the writ petition.
you have not supplied the copy of the
That's
writ.
what he was expressing. Didn't he?
You supplied the copy of petition to them. Heard Mr. What's your name? Venison V. Choi, learned counsel for the petitioner. Also heard Mr.
R. Muli.
R.
Muli.
Nuli,
Yes.
learned counsel for respondent number 6 to 14. On perusal of the office note dated 6/2/24, it appears that state respondents have not filed any affidavit yet. Though no one is present today on behalf of the state respondent. However, Mr. R. Nuli,
Lordship.
learned counsel for the state, respondent number 6 to 14, has informed that he has been informed by learned government counsel that he has not yet received the copy of writ petition. Stop, sir. Considering the submissions made by learned counsel for the respondent number 6 to 14, the petitioner is hereby directed to furnish a copy of the writ petition to the government council so as to facilitate filing of affidavit in opposition by the state respondent. Let this man, when will you file? Today itself you give a copy. Within the petitioner shall furnish the copy of the writ petition within 2 days from the date of this order. Let this matter be listed again after 2 weeks.
Yes, Lordship.
For admission, item numbers 13 and 14.
Yes.
Lordship, for the petitioner in the criminal revision petition, the opposite party has filed an appeal. For the bring for the court's directions for non-compliance, the order the letters for them. In the last occasion, we have some time, a week's time, to take to make interviews to fulfill the payment, make the payments which we're supposed to pay. However, we have made all our interviews to convince the client, to instruct the client to comply to the orders. But since it could not be done, I leave it to the discretion of the court.
You are for the respondent.
It's in the idea. For the petitioner in the criminal petition.
No, let me understand. Why this petition was, criminal revision petition was filed, challenging what?
For
quashing.
To quash the criminal complaint.
Okay. Criminal complaint filed by the,
Filed by the respondents, the complaint, criminal complaint 1 of 2022.
so there was a amicable resolution of the, how much money you were to pay?
51 next.
Okay. Okay, in this case, notices were issued in the main revision petition. The complaint case was stayed and the date was fixed on 18/3. Okay, now what happened?
Lordship, if I may be allowed to make a prayer, allow me to withdraw our vakalat in this case.
No, then you have to inform the
Yes,
clients.
we have informed them. We have even sent them notice this morning. Since we have made every interview.
Where,
we
where,
informed them.
where is the, you have to. The,
We have wrote a letter to them this
Yes.
morning. However, if necessary, formal steps are needed to be taken. we will do.
you have to inform them
Yes.
through registered post with Haley.
Lordship, that can be done.
Then we will fix this case on 18th. Because otherwise the main case is fixed on 18th.
If that's the case, Lordship.
What miss, what's your name?
It's a crime.
K?
It's a crime.
This is item number?
13 and 14.
Okay, Supro. TSU. Learned counsel for the petitioner. None has appeared for the respondent. It appears from record that this interlocutory application was registered on filing of a petition by the respondent in criminal division number 3/2023 filed by the petitioner. No, filed by the petitioner. no. Wherein wherein it has been stated that in spite of an amicable settlement between the petitioner and the respondent to make payment of amount of rupees 51,08,800 to the petitioner of this interlocutory application. And in spite of the fact that one last chance was granted by the petitioner by this court to the petitioner by this court by order dated 26/2/24. No effort has been made to comply with the amicable settlement arrived at between the parties. Learned Ms. K. Sukru, learned counsel for the petitioner, submits that she intends to withdraw the Vakalatnama and has already informed the petitioner by sending a written letter today. She also seeks some time for sending the intimation to the petitioner by registered post with AD. The prayer is allowed. It also appears that the criminal revision number 3/23 is fixed on 18/3/2023. Let this interlocutory application be also listed along with said case on 18/3/2023. In the meanwhile, learned counsel for the respondent may take steps as desired by her. List accordingly.
For orders, item numbers 20 and 21.
Vishek, some corrections would be required in this order. You show it to me later. Yes.
Your Lordship, appearing on behalf of HHP. This matter is about coalition of misleading.
But the notice issued to respondent number 4 is yet to be, is not yet served. What, yes, what to do? Will you take fresh steps or should we await, sir, report? Notice to respondent number 4 is not yet served. You are appearing for the state respondent. Let us wait for some time. Heard Mr. Benizon V. Soy, learned counsel for the petitioner. Also heard Mr. V. Zimomi, learned counsel for the state respondent. It appears from office note dated 29/11. You take fresh steps. Okay, sir. 29/11/2023, that the notice issued to respondent number 4 is yet to be served and no report has been received by the registry regarding service of notice on the said respondent. Let this service report be awaited for some more time.
Interim order may continue.
Let this case be listed after 2 weeks. The interim order shall continue till next date.
For hearing item number 28.
Ready?
Lordship.
Ready for hearing. Both sides ready.
Lordship, before I proceed, I just want to apprise this court that, the, state respondent from the district administration, as well as, NHCL have also recently conducted an assessment, Lordship, survey of the petitioner's land. And, this record may not be produced by the state respondent, but I have a copy for your kind reference, Lordship.
What is the issue in this case?
Lordship, the issue is that the petitioners are aggrieved.
What is your name?
Nitya Kosa, Lordship.
Yes, what's the issue here?
Lordship. Yes, Lordship. The issue is that the petitioners were aggrieved because for the construction of 2 land lots, Lordship, in their, it's the private landowners.
Roads.
Road, Lordship. It's a road construction project. So their land were affected, Lordship. So they were not paid land compensation. That is why they are before this court, Lordship, because these are solely the land that has been affected. and the parameters of the land who belong to the petitioners falls within the land of private land ownership lordship. So except for one of the petitioner, the rest of the land falls within one town lordship, which is outside the parameters of village lordship. But before I proceed further lordship, I would also like to apprise this court that there are three petitioners. They do not wish to continue with the case. Petitioner number 9, 16, and 17. I've been instructed that some arrangement has been made.
You are
Yeah.
representing them. You are
Yes,
also
I was representing all of them.
all of them.
Yes.
Out
17.
of those 9, 16, and 17, don't
Yes.
want to pursue this case.
Yes, because they have reached a settlement with the authorities concerned. So perhaps they were offered some amount and they are okay with that lordship.
Okay.
So we don't know whether they have received the money, but I was instructed that they don't want to proceed with this case. So lordship, that then only with that only 14 petitioners remains out of 17.
Okay.
So lordship, in fact, in this case, IA was also filed. IA was also filed praying for staying the execution of road project because the petitioners were very concerned because already the standing crops and the damages was already done without
What has happened in IA? Whether it is still pending?
It is still pending, so this can be both heard together, lordship. The report that I've sent you, that I just finished before this court, it's also the outcome of the following outcome of this court's order, lordship, because lordship, earlier the state respondents have also filed an affidavit wherein they were directed by this court to carry out assessment, lordship, to verify whether the land, the claims of the petitioners are genuine or not. So lordship, the district administration has filed their affidavit and there is no contention as far as to the title of the land, lordship. They also agree that yes, the lands are affected, but the decision thus far was that they cannot pay land compensation and they can only pay damage compensation, lordship, for the damages caused. Most of these lands are, some of the lands were used as agricultural land, while some were used as
What is the contention of the respondents that they will only pay
not damage
damages?
compensation, not land compensation.
Cost of the land they will not pay?
They will not pay. That is why the
Oh,
petition.
Why? What?
Because lordship, there's a notification which is impugned in this petition. Lordship, if you would kindly go to page number 146, lordship. We are impugning this notification issued by the state government, issued through the Chief Engineer, Public Works Department, National Highway, wherein it states that
This notification dated 14 December.
yes, 14 December 2011, lordship. These concerns.
What it says?
It says that government has decided to give land free of cost for development of 329.00 kilometer land of roads under SARDP and E in the state, and acquisition of land does not arise. This is the decision of the state government. Now, as far as the land of the petitioners are concerned, lordship, they are impugning this, lordship, because petitioners here are mostly are from a poor family, lordship. With much toil and hardship, they could somehow purchase small plots of land, and they're not willing to. Yes, they have no choice since road is to be constructed. They have no choice but to part with the land. But now they're saying that yes, you take our land because we have no choice to oppose, and we know that the road is a requirement. So we also we are okay with that, but at least give us the land compensation. This is what they're demanding. Even the land value is also not much. Lordship, in the land where the petitioners are coming from, Lordship, land value is not much, and it won't cause much liability upon the respondents as well, Lordship. Now, Lordship, the stand of the NHIDCL, Lordship, as far as the land compensation is concerned, the petitioners have given the one representation to the NHIDCL as well. So in their response, they have mentioned, Lordship, that it is because of this, the impugned notification, where the state government said that the land is, free, should be given free of cost. This is why they are unable to release the amount, Lordship.
But this free of cost, this pertains to which land? Government land only?
No, the government doesn't.
Because here government does not have land.
Yes.
Land is owned by private individual.
Yes, and we also protected under Article 371A, Lordship. Now, the land, the petitioners are solely private landowners in this case. And so, Lordship, the law is very clear, Lordship. They are entitled to land compensation. Yes, at the time of filing this petition, we thought the Act of 2013 was applicable in the state of Nagaland, but when we further inquired, Lordship, it says that it's not applicable, 2013.
The
Land Compensation Act, Lordship, but we still have our own state act, Lordship.
2013 Act is not applicable.
That is what the state government say, because it's not been passed in the state legislative assembly. But we have our own.
No, why it is not applicable?
Lordship, they have not passed, the state legislative assembly have not passed the act, Lordship, in the house. So,
No, but it is a central legislation.
It is a concern because a lot of projects are ongoing, Lordship, but many of the landowners are aggrieved because of that, because of not being paid adequate compensation, Lordship. But Lordship, even if 2013 Act is not applicable, we still have the 1965 Act, Lordship. We have a specific act called the Nagaland Land Acquisition and Acquisition Act, Lordship. And under this act, Section 11 clearly states that the petitioners are entitled under Section 11 of the Act, Lordship. And also detailed procedure has been made on how the land should be acquired in that 1965 Act, and then the value, how it has to be determined, Lordship. All these things have been given, so the petitioner still can claim under this, as well as under Article 308, Lordship, of the Constitution. Now, Lordship, I would say that through the intervention of this court, the case has also progressed, because the latest report that I just furnished, Lordship, 13 of the land, the petitioner's land were assessed, Lordship. Proper measurement was also taken. If you would see, Lordship, the details of the land, the particulars are mentioned in the last page.
Okay.
So I was informed that.
How much land has been used for?
Yes, for the construction.
For the road.
Yes.
Okay.
So this survey is conducted in the presence of the NHIDCL.
But there are total 17 numbers of petitioners.
17, but since 3 of them are already backing out, so the land was not ascertained. But the overall vision understanding.
Still 14 remains.
Yes, 14 remains. So one person's land falls within the heavy area, Lordship, it seems. That's why his land is yet to be verified and measurement is yet to be taken. This is what I was informed, Lordship.
Who is that petitioner?
That is petitioner number 12, Lordship.
Okay,
So Lordship, it's given in serial wise, Lordship, the land record. Gating, one of the petitioners' land, the affected land is 3,150 square meter. Then Hindi Church Society, 1,000 square meter. Miss Avanti Konyak, 2,700 square meter. Aji Konyak, 2,700 square meter. Polai Konyak has 2 plots, combined 3,200 square meter. Kaplau Konyak has 1,350 square meter. Ahon, 3,000 square meter. Pangloi Konyak, 2,700 square meter. And Wakho Konyak, 12,000 square meter. Kamo Konyak, 1,800 square meter. Ashing, 1,600 square meter. Lamding, 1,400 square meter. Nyamlang, 900 square meter. But Lordship, from this record, we can see that though the measurement is taken, but then the award is yet to be made.
no, this survey was conducted as per this court's order.
Yes,
Or-
subsequent to the court's order, Lordship.
No, whether there was a court order or whether they,
Yes,
Conduct-
Lordship,
which,
there was a court.
which order? This kind of.
Lordship, as per order dated 21/11/2022, this court has directed the state respondents to conduct proper verification of the land of the petitioners.
So as per that order, this survey was conducted.
So, yeah, there was another survey was conducted on another date, wherein the affidavit was also filed by the state respondents, Lordship. Thereafter, after filing that affidavit again, this was conducted, Lordship. Yes, Lordship.
Now, what is your contention that who will pay this compensation, state or the NHI?
State will award compensation, then NHIDC will release the fund, Lordship.
And your submission is that according to 1965 Act, this compensation should be released.
Yes, Lordship, since 2013 Act is not applicable, I have no choice but rely on 1965 Act, Lordship.
Okay.
Lordship, I would request this court, before this matter is closed, since there's a development in this case, Lordship, and only one petitioner's land is yet to be measurements to be taken. And already it is a proof itself that land exists, the petitioner contention of the petitioners are genuine. So Lordship, if an award can be made by the Deputy Commissioner, Lordship, then accordingly, and if petitioner number 16 or 12, land is also verified, then accordingly, Lordship, this matter can be closed.
No, now your submission is that we should not continue hearing this matter.
Lordship, it's my suggestion. that
Before that,
closing the case, Lordship.
the survey of the land of petitioner 16 should also be done.
Lordship, because there's much development has been taking place, Lordship.
Okay.
So I think
What is your submission?
the state respondents, a lot of objection.
Lordship, as per the page 158 of the with petition, being filed by the petitioner. Page 158, Your Lordship. May I read the relevant portion, Your Lordship?
What is this?
This is the consolidated, the minutes of the consolidated meeting held on
21st.
No, 158 is a chart only,
Of the writ
writ
petition.
petition.
This is the minutes of the consultative meeting held on 21st
No,
September 2017.
page number 158.
158, Your Lordship.
This is a details of the area dimension property and compensation offered by NHIDCL.
Your Lordship, I'm referring to this writ petition.
Yes, I am also on that writ petition 213,
I'm referring 158, Your Lordship.
page number,
158,
page,
page 158, 158.
but page 158
Yeah.
is a chart here.
One, 15. No, 154. The type copy is at 158.
No, here there is some mismatch. Page 158 is a chart which lays down the details of the property and compensation of.
This is the copy served by the petitioner. I'm trying to read the.
No, which one?
This is the minutes of consultation.
Give this. Give this. You see the
Lordship,
copy
it's,
on.
The original copy is from 155.
No, you check in my copy.
This is the program served by. Use the second copy. Second copy. Second copy.
See. See.
What is the page?
154. This is the type copy. 154 is the type copy. This is 157.
The right copy. 154 is the.
It is 154.
That is the original copy and I'm trying to read from type copy.
But it's Mr.
Type copy is at page.
158, but starting from 157.
Okay, but here it is not there.
You know,
Because in 158, there is only a chart. You can. Give
I'm
this,
relying on this written petition, a copy.
but your copy and my copy should match. Otherwise, I will not.
Your copy, my copy, the NICDCL's copies are all correct, Lordship. It's just that somebody must have, while making photocopy.
No,
they
what is
must
that?
have made a mistake.
Your Lordship, I'm trying to refer.
You look at your copy, where is that page to which he is referring to?
May I read, Your Lordship?
Which at page?
154.
Yes,
And
154, it is there.
this
What-
is the minutes of the consultative meeting held on 21st September 2017 at Secretariat Conference Hall regarding 4-lane SARTP roads and Kohima bypass. The relevant portion is para 5. No. Your Lordships, there are 60. 155.
6D.
Yes, Your Lordship. No land compensation will be made in line with earlier arrangements for SARTP roads.
Okay,
Compensation for the damages already caused to the properties during earlier construction will be paid by the contractor that is Mita's secretary, through arbitration process, which is expected to take place soon. And for the damage compensation,
Okay, okay.
we have made an appeal before the Honorable Delhi High Court for every arbitral award, which is still subsidized in the Delhi
Regarding what?
for payment of damage compensation.
No, but their contention is that you cannot deprive them of their land compensation. Merely because there is an arrangement between state government and NHIDCL. Because law says that the Act of 2013 says that land compensation is to be given. Act of 1965 also says that land compensation is to be given. So what is your basis for depriving the landowner of the compensation for acquisition of the land?
In the state of Nagaland, Your Lordship, we don't have good road. We need good road for all the developmental activities.
Yes,
be it
but,
for-
but payment has to be made for that.
That was how this consultative meeting was held with all the tribal hosts, particularly the 6 tribal hosts, in which area this SRATP road 4-lane, including Kohima bypass, was to take place. That was how this was. the
No,
consultative
no, I
meeting.
want to understand. The landowner are not denying that they will not give their land. They are saying that we are ready to give our land, but you have only to compensate them. Why not to compensate them? What is the logic?
This is the minute, and landowners, they were supposed to be paying damage compensation only, not the land compensation.
But in
There
this,
was no acquisition of land, and thereby they were assured to pay damage compensation.
without acquisition of acquiring the land, how are you constructing road over a private land without acquiring it? I'm not.
This was the arrangement made by the state government with the landowners. Your Honor.
But when there is a law which details how to acquire land for infrastructural projects, for road constructions, you have to comply with that. I just want to understand. Now, her submission is that as per the order dated 21, 2022, you made survey of the land, which is land of the petitioners, which is used for the purpose of construction of the road. And one person is left out, one petitioner is left out. So her prayer is that let us go through that 2111 order.
Your Lordship, here, the state respondent number 3, 4, and 5, 4, 5, and 6 had filed our affidavit on 6 June 2023, Your Lordship. If I may be allowed to read.
No, but let us first decide, are we going to hear it finally? Her submission is that before hearing it, that survey should be completed. On that, do you have any submission?
Your Lordship, here, the copy which my learned friend had already supplied the copy.
But
I'm yet to receive officially.
This
So
has
I'm-
not yet been submitted. Let them submit it officially.
I may be allowed to.
Because he also
Receive
don't know,
instruction.
you don't have the
No.
instructions.
True, yeah. I may be private.
No, you are referring to this order dated 21/11/22. But on that day, no such order for survey was passed by this court. Which, which, which one is the order? 14?
14 February.
Whether it is in IA or in.
I, Lordship.
Okay. Nice. Yes, there was an order
Yes.
where the verification.
Assessment verification was done and my annexure D, page 19. Is the latest assessment made by the respondent.
Page 19 of.
My affidavit, respondent number 4, 5, and 6 affidavit. Filed on 6 June 2022.
Yes, affidavit.
All the petitioners' plot have been assessed, verified, and the amount indicated to each petitioners have been given notice.
Lordship, but this is just a damage compensation, Lordship.
Which page you are reading?
Page 19, annexure D of my affidavit. Affidavit being filed on 6 June 2023. A compliance affidavit for and on behalf of the respondent number 4, 5, and 6, respectively bringing on record as directed by the Honorable Court's order dated 23rd January 2023 for submission of compliance report. And I filed on 6 June 2023, Your Lordship.
No, yes, they have complied with the directions.
Lordship, this is, yes, they comply with the court's order, but the thing is, Lordship, in the sense that I have also filed, my reply to this affidavit, the last file, Lordship, because there, on the spot verification was not conducted, but they're saying that previously, when they have verified, that should count. That is what they are saying, Lordship, even in the affidavit, that is why, here, Lordship, the award that is, the amount that is mentioned is to do with damage compensation only, Lordship. because they have standing crops and timbers in their land. So those which were damaged, they are referring to that. So, Lordship, the latest assessment that was made, Lordship, if the state respondents wants to take time, let him take a call on this and seek instruction, Lordships.
No, the survey report which you have furnished today is of 17 January 2023.
Lordship, the date must be mistaken because here the joint survey team was conducted on 19 December 2023, Lordship.
Which date is wrong?
The letter dated is wrong. It should be 24, because I just received this last week, Lordship, from the petitioners. If you would kindly allow me to read the survey report.
No, before that, why we are reading this? What is the relevance?
Lordship,
What do we propose now? Whether
Lordship.
we can go for hearing of this case and finally decide everything in the case.
that can be done, Lordship. if they're ready.
That option is there.
If they're ready,
in-
that can be done. But
If any direction is required,
Lordship,
we may pass it in final order instead of passing piecemeal orders.
Lordship, but my learner friend is also saying that he wants to take instruction on this. I'm saying that. If he wants to take
Otherwise,
instruction
Your
on
Lordship,
this,
if I may be allowed to read my affidavit.
No, this case was fixed for hearing.
Yes,
It has come in hearing column.
Lordship,
My simple query to you is, are both of you are ready for hearing? If it is, you are ready, we will go for hearing. Or
I'm
we,
ready,
or
actually.
otherwise,
yet receive officially instruction about this latest.
then you take instruction, then we will go for hearing.
objection for that.
Instead of passing, because if we pass a order which, again, it will take this case 6 months back.
The Lordship, yes. So to reach a meaningful closure of this case, Lordship, if he wants to verify and take
Yes.
instruction, the time may be given, Lordship.
I may be granted 3 weeks time, Your Lordship, since the location is known far away from.
Heard Ms. Nityo Koza, learned counsel for the petitioner. Also heard Mr.
LD something,
L.T. Sanktam,
additional age.
learned additional advocate general, and Mr. Moa Zamir,
Lordship.
le-
For respondent
learned
2 and
counsel
3.
for respondent number, who is 2 and 3?
NHIDC.
And you are for NHI, you are for state government.
I'm for state 4, 5, and 6, Lordship. Along with my. brother.
Also heard Mr. V. Zimomi. Learned counsel for the petitioner submits that in pursuant to the directions passed by this court on 21/11/2022, the respondent authority have conducted a survey as informed to learned counsel for the petitioner by the petitioners, who have also furnished a copy of survey report to the learned counsel. How it is also submitted that in the said survey report, it appears that survey of the land of 13 petitioners has been done, and petitioner number 16 has been left out as
Lordship, petition number 12.
petitioner number 12 has been left out as his land is situated over a hilly area. Stop. It is also submitted by learned counsel for the petitioner that the petitioner number 9, 6 and 17
16, Lordship.
9, 16, and 17 do not want to pursue this writ petition as they have already arrived at a settlement with the respondent number, with the respondents. Stop. Learned additional AG, Mr. Sankam submits that he does not have any instructions regarding the survey report which has been produced by learned counsel for the petitioner in the court today, and seeks some time for taking necessary instructions in this regard. Learned counsel for both the sides also submits that this case may be finally heard after learned additional AGs gets the instruction as sought for by him. Considering the submissions made by learned counsel for the parties, this case is adjourned for 3 weeks. And in the meanwhile, the learned counsel for the respondent shall obtain necessary instructions from the respondents in this regard. Let this matter be listed after 3 weeks in hearing column.
Obliged to mention.
Please give me name. 28. This one need to go. And this one. LTSANG PA. Sometime additional AG. Assisted by Mane VG. This one is PP, na? And Moazem MOAZEMIR, na?
Tôi làm gì được cũng sửa lại. Ủa ta kia vậy nè.
Non sa.
Thì cái difference.
Vamos ver. Oi.
You there, Rick does it.